So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. In this lecture series, we cover entire 1 year's current affairs, important topics from those current affairs. Now we have divided all these important topics from past 1 year's current affairs into subjects and we are covering these subjects one by one. We are done with economics and currently we are continuing with polity. Okay, so today is another lecture in Prelims Powerplay Polity lecture series. And today's topic of discussion or today's topic that is going to be covered would be fundamental rights. Okay, so all the important news items, all the important current affairs from the past 1 year with respect to fundamental rights shall be covered today. All right, so without further delay, without further ado, let's start with today's lecture. Okay, so Prelims Powerplay Polity lecture series, and we are going to start with fundamental rights. Okay. Now, in the topic of fundamental rights, what important news items were there in the past 1 year's current affairs that we are going to cover in today's lecture? Let's take a look. So, topics to be covered today. First of all, we'll talk about Section 79 of IT Act, Information Technology Act. Please don't mistake it for Income Tax Act, okay? Section 79 of Information Technology Act. We'll talk about this. Then, we will talk about the concept of or the doctrine of essential religious practice. As you all know, that freedom of religion is a fundamental right guaranteed as per Article 25 of our Constitution. But it protects only essential aspects of your religion. So what is this doctrine of essentiality? We'll talk about this. Then we'll talk about the concept of passive euthanasia. Okay? Basically, right to die. Then we'll talk about private property and common good, right to private property. And in the end, we'll talk about right to be forgotten. Okay, so these are some of the fundamental rights that were in the news in the past 1 year. And there is a high chance that this year's prelims can carry questions related to these topics. So let's discuss them. Okay, let's discuss them one by one, starting with Section 79 of IT Act. Now, the reason why this was in the news was because Elon Musk challenged this section of Information Technology Act in the court. Elon Musk. And why did Elon Musk challenge this? Because Elon Musk has a company called X, erstwhile Twitter, right? It is a social media platform. And he is not happy with Section 79 of Information Technology Act in India. Now, why is that? Well, Information Technology Act basically regulates all the content, everything that is posted online basically, okay? And this Section 79 is something that Elon Musk is not happy with because he says that it gives the government arbitrary power to censor anything on social media platforms, okay? That's his argument. He says that this Section 79 is against freedom of speech and expression, which is also a fundamental right as guaranteed by Article 19 of our Constitution, right? So what is this entire issue about? Let's talk about this, okay? So Section 79 of Information Technology Act. Now, to understand the challenge presented by Elon Musk to this section, you need to understand some background with respect to Information Technology Act. And that background contains some of the past judgments of the Supreme Court. The first and foremost among these judgments is Shreya Singhal case. Okay, you see, back in 2015, there was this section in Information Technology Act called Section 66A. This Section 66A basically allowed the government to criminalize any content posted online which is considered unlawful. So under this Section 66A, basically, government could arrest you for posting something online, okay, if government believes that that is unlawful. Make sense? So if government believes whatever you have posted online is unlawful for the reason of, or your purpose of posting that content was to sow enmity, break law, then government could arrest you. So this Section 66A basically criminalized this. Now, Shreya Singhal challenged this provision in the Supreme Court and Supreme Court basically struck this down. Supreme Court said that this is basically violative of fundamental rights, okay, especially freedom of speech and expression. And because this particular section is vague, it gives government arbitrary power to arrest anyone who has posted their personal beliefs. Clear? So this section 66A was struck down. Clear? Simple. Make sense? But we cannot hide from the fact that there is definitely some illegal content floating on social media platforms, right? There is hate speech on social media platforms. There is illegal content on social media platforms. So how does the government deal with it right now? Earlier they had section 66A. So how does the government deal with that illegal content on social media platforms now? How does the government deal with that? For that, there is section 69A of Information Technology Act. And as per section 69A of Information Technology Act, government can order, okay? Government can basically order any social media platform or any online platform to remove unlawful content. So it doesn't criminalize who has posted. This section 69A will just order the platform, online platform, to remove that content. Clear? Now, many people were concerned that section 69A can also be misused by the government to remove lawful content under the guise of it being unlawful. Government can also remove content which it thinks is anti their party, criticism of their political party, right? Many people were concerned that section 69 can also be misused for blocking content. So Supreme Court under Shreya Singhal case gave some safeguards. Okay, Supreme Court said that if government is to pass any order to block the content on social media platforms, well, for that the Supreme Court says that the government has to give reasons why it is doing so. And those reasons can only be based as per Article 19 Clause 2. Okay, as you can see over here, for blocking content under Section 69A, the center must deem it necessary. The center cannot pass randomly this order. If the center is passing this order, if the government is passing this order, the government has to explain why was it necessary to do so. Okay, and the Supreme Court also said that the justifiable grounds for this necessity are mentioned in Article 19 Clause 2 of the Constitution. Basically, Article 19 Clause 1 says you have freedom of speech and expression. But Article 19 Clause 2 says that the government can put reasonable restrictions on that. For example, blocking hate speech and all. So there is freedom of speech and expression, but government can put reasonable restrictions. Those reasonable restrictions are mentioned in Article 19 Clause 2. Yes. So the Supreme Court said that it can only be removed if government can prove that the reason why they are blocking this content falls under these reasonable restrictions, and the government has to explain in writing why they are giving this blocking order. So this is a good enough safeguard, right? This is a very good safeguard. Then why is Elon Musk angry, right? Well, I'll tell you. Elon Musk is angry with Section 79 of IT Act. And let me explain to you what Section 79 of IT Act is. Section 79 of IT Act gives safe harbor. It is the safe harbor provision. Safe harbor provision is provided to intermediaries. Okay, mostly social media platforms. Now, what do we mean by safe harbor? You see, if you post any unlawful content on your website, then you will be prosecuted. But if you post any unlawful content on Facebook, then why should Facebook be prosecuted? It is Facebook's website. But Facebook shouldn't be held accountable for any random person posting anything unlawful, right? So generally the rule is that if it is your website and any unlawful content appears on your website, you shall be prosecuted. But safe harbor provision means that you won't be held liable for anyone else posting unlawful content on your platform. This is the safe harbor provision. Okay. So Facebook, Twitter, Google won't be prosecuted for anything unlawful on their website. This is safe harbor. But Section 79 clearly says that this safe harbor won't apply to these social media platforms if the government tells them to remove any unlawful content and they don't remove it. So if government says to Twitter that this is unlawful content, please remove it, and Twitter refuses to do so, then safe harbor won't apply. Okay? But many people were concerned that this can also be misused by the government. So the Supreme Court gave some safeguards. Okay, Supreme Court said that the order should be either through a notification of the government or through a court order. So if court orders Twitter to remove anything, and if Twitter refuses to comply, then safe harbor would get redundant. So all these orders given to Twitter, Facebook are given under Section 79. But Elon Musk says that the safeguards provided under Section 69 are not applicable in Section 79. Okay, that the government can only give a blocking order if it is covered under Article 19 Clause 2 reasonable restrictions, and government has to give in writing also. All of this is not required. That is why all these blocking orders are given under Section 79. But Elon Musk says that it should be given under Section 69A because it has reasonable restrictions. But government is giving all these orders under Section 79. Clear? That's his argument. He says give primacy to Section 69A and cut off Section 79 because it is vague and it curbs freedom of speech and expression. That's his argument. Now, what you should remember from this is, don't remember Elon Musk or what his argument was. Just remember what Section 79 is, what Section 69A is, and what was Shreya Singhal case. Alright, that would be all. Now let's quickly shift to essential religious practices. The thing is that our constitution guarantees a fundamental right, and that fundamental right is freedom to religion. Okay, it is covered under Article 25 to 28, but Article 25 specifically gives everyone the freedom to freely practice, propagate their religion. That is why Article 25 is also said to be freedom of religion article. This is the fundamental right. Basically, Article 25 is that fundamental right which guarantees secularism in our country. Okay, secularism of our country, Indian secularism, comes from Article 25 because it guarantees everyone the right to freely practice, profess and propagate their religion. Okay, but the thing is that in that same constitution, there are reasonable restrictions applicable on this freedom of religion as well. The thing is that the constitution says that not everything in a religion is basically allowed. So, for example, if someone is practicing child marriage in the garb of religion, saying that it is written in some of our scriptures, okay, saying that it is allowed or it is our norm, it is part of our religion, then government can basically stop that. You understand my point? So certain activities of religion can be regulated, can be stopped by the government, and people cannot claim freedom of religion to protect themselves, right? Now, how to decide whether these religious practices should be controlled, these religious practices should be allowed? For that, Supreme Court basically passed a judgment, and that really helps us, okay? And that judgment gave the doctrine of essential religious practices or doctrine of essentiality. So let's talk about it, okay? So essential religious practices. So first of all, let's talk about Article 25. So it has two clauses. It ensures that all individuals have the freedom of conscience and all individuals have the right to freely profess, practice and propagate their religion. But under the same article, reasonable restrictions are applicable. If the state feels that those religious practices are harmful to maintaining public order, morality, health of people, right, then you can control or regulate those religious practices. Now, state has regulated those religious practices in the past, and those people against whom the state took that action, they went to the court and they said that the state is violating our Article 25, fundamental right. Okay. So therefore, to solve for this problem, Supreme Court gave a judgment. The famous judgment of Shrir Mutt case. Okay. Shrir Mutt case. So it is a landmark Supreme Court judgment that significantly shaped the understanding of religious freedom and the role of state in religious matters. The Supreme Court made it clear that yes, you all have freedom of religion. Your religious rights are protected. But only those religious rights are protected which are core to your religion, which will be considered an essential practice to your religion. Not everything in your religion would be protected, only essential parts of your religion, essential practices of your religion shall be protected. And the non-essential practices would also be only curbed if they harm public order, morality or health. Otherwise, they would also be allowed. But if your non-essential practices are being controlled by the state, then they would be controlled on those reasonable restrictions ground. Okay, so Supreme Court basically in this Shrir Mutt case gave the doctrine of essential practices or doctrine of essentiality. Now, every time there is a case in the Supreme Court with respect to Article 25, that our fundamental right to religion is being violated, like the Triple Talaq case also, okay, the Supreme Court has to certify whether that particular practice is essential practice. If it is not, then state can control it. So the Supreme Court ruled that Triple Talaq is not an essential practice of Islam, and that is why government can make a law on it banning it. You understand the point? So this is the doctrine of essentiality. Clear? Now let's move on to topic number 3, and that topic is of passive euthanasia. The thing is that recently in UK Parliament basically passed assisted dying bill. Okay, so United Kingdom, Great Britain passed assisted dying bill. Now, what is this assisted dying bill? This assisted dying bill basically allows anyone who is terminally ill and who has no chance of recovering. He's just bedridden, terminally ill. Then he can give his consent to die with dignity. So basically, assisted dying means assisted suicide. So if anyone is terminally ill, they can give their consent to be given a lethal injection and they can die peacefully. Because some people feel that this is living a life like that is not living a life with dignity. Therefore, they want to end their life because that is painful. So that is now allowed in United Kingdom. Now, the process of dying with dignity, or the this term or this concept of assisted dying or giving consent to die is known as euthanasia. Okay. Now, UK has allowed euthanasia, assisted dying basically. What are the provisions with respect to India? Does India allow this or is it banned in India? What are the provisions with respect to that? Okay. That is the topic of passive euthanasia. So let's start. Okay. So passive euthanasia. So euthanasia basically means assisted suicide. That you want to end your life and someone is helping you to end your life. Okay. Now euthanasia is of two types. Active euthanasia, passive euthanasia. Now active euthanasia means that you are conscious but you are terminally ill. You are bedridden. Okay. You are just continuing your life but you are conscious. And then you give consent to someone to end your life, give you a lethal injection so that you can die peacefully. Okay, this is active euthanasia. Okay, what is passive euthanasia? So active euthanasia is someone gives you lethal injection so that you can die. Passive euthanasia is that maybe you are in a state of coma and you are alive because you're on ventilators. Okay, you're not conscious and you are only alive because you're on ventilators. As soon as you'll remove the machine, you will die. So passive euthanasia is removing the plug of that machine. So you are not conscious to give consent also. Okay, you're not conscious to give consent and no one is giving you a lethal injection. They are just removing the life support system from you so that you can die a natural death. You would have died The person would have died if medical science was not so advanced. So you just remove the life support system and the person dies naturally. This is passive euthanasia. Now, as far as India is concerned, active euthanasia is not allowed. Though now it has been allowed in UK through assisted dying bill. In India, active euthanasia is not allowed. But in India, passive euthanasia is allowed. Okay? And it was allowed in 2018 by the Honorable Supreme Court. The Supreme Court, in a case in 2018, said that we have this Article 21 of our Constitution which guarantees right to life. Okay? This is a fundamental right to life. Yes? Now, Supreme Court says that right to life also contains right to die with dignity. Okay? It is part of right to life. So, right to die with dignity is part of right to life. Therefore, right to die with dignity is part of fundamental rights. Right to die with dignity is your fundamental right that is given to you. The Supreme Court made it clear that though right to die with dignity contains euthanasia, it only contains passive euthanasia. No one can say that give me a lethal injection so that I can die. No, only passive euthanasia. That means removal of life support system. Simple. So, right to die with dignity is part of Article 21 of the Constitution. Through this, the Supreme Court recognized the legality of passive euthanasia. And remember, the definition of passive euthanasia is the withdrawal of life support from terminally ill patients or patients in a permanent vegetative state, in coma, lying on the bed. Vegetative state means that. Now, Supreme Court says that passive euthanasia is allowed, but this passive euthanasia should be conducted with utmost care. And to ensure that it is conducted with utmost care, Supreme Court gave some guidelines. Some of those guidelines are as following. Okay, so if a person is in coma or in vegetative state, then you can take consent from his family members, his or her family members, to give this passive euthanasia, remove life support system. Or if the person himself, before he was in that vegetative state, when he was fully conscious, basically wrote a will, which is known as living will or advance medical directive. In that living will, he should have mentioned that if he gets to that stage, if he gets to that vegetative state, then you should remove his life support system. Okay? So if a person consents to his passive euthanasia well before he is in that state, or his family members give that consent, well, it should be done. Living will must be signed in presence of 2 witnesses and judicial magistrate. Plus, there are multiple layers, multiple approvals that you have to take for passive euthanasia to happen. There should be a doctor's approval, medical board's approval, external medical board's approval, local administration's approval, judicial magistrate's approval. There are so many procedures that you have to follow, paperwork to follow, then only passive euthanasia can be allowed. So that is the situation in India. Passive euthanasia is fundamental right. Simple? Okay. Let's quickly move forward to topic number 4, and that is private property and common good. Now, the thing is, when our constitution was enacted, okay, private property was a fundamental right. But under the 44th Constitutional Amendment Act, private property was removed from the list of fundamental rights and was made an ordinary legal right. So, right to property, when the constitution came into being, right to property was a fundamental right. But after 44th Constitutional Amendment Act, it became an ordinary legal right. Now, there are many cases with respect to right to property, especially when government wants to acquire your private property. Can government do so? Okay, can government forcefully acquire your private property? There are so many judgments and so many constitutional provisions with respect to that. So all we have to do is just concentrate on the constitutional provisions and the Supreme Court's judgments with respect to private property and states' authority in acquiring it. Clear? So private property and common good. Basically, common good means that state is acquiring your private property for common good of all. Clear? Now, as per Article 31C of your constitution, state can acquire your property. But there are certain conditions under which state can acquire your private property. Okay, so let's take a look at Article 31C. So Article 31C had two provisions. Provision number 1 was no law giving effect to the policy of state towards securing the principles specified in Clause B or Clause C of Article 39 shall be deemed to be void on the ground that it is inconsistent with Article 14, 19 and 31. Okay. Basically, what this provision says, that if the government is enacting any law or taking any action for implementing Article 39 Clause B and Clause C, then that action cannot be questioned in court that it is violative of Article 14, right to equality, Article 19, which included right to property, and Article 31, which also included right to property. Okay, so no action of the government can be challenged if it is violative of Article 31, if the government proves that it is taking this action to implement Clause B, Clause C of Article 39. Clear? Now, Clause B, Clause C of Article 39 is basically directive principle of state policy. Basically, it belongs to Part 4 of our Constitution, which is directive principles of state policy. It is from Article 36 to 51. You all should know this by now. So, if you are implementing directive principle as mentioned in Article 39, Clause B, Clause C, then that action won't be challenged. Then that action won't be declared null and void. It will be challenged, but won't be declared null and void if it violates Article 14, 19, 31. Clear? Then the second provision was that if government says that we are basically taking this action and this action implements Article 39 BC, okay, if we give that in writing, then you cannot even question that action in the court. So first provision says that the government can take an action violating your fundamental rights if it implements Article 39 BC. The second question is that that action cannot be questioned in a court of law. Okay, you have to just accept that the government is implementing Article 39B or C. Even if the government is not implementing, if the government writes that we are implementing BC, then too that would be permissible. Clear? Now these two provisions were added in the Constitution. Basically, Article 31C was added in the Constitution by Indira Gandhi government under 25th Constitutional Amendment Act of 1971. Okay. Now this amendment was challenged in the Supreme Court. Now, the Supreme Court in the landmark Keshavananda Bharati case said that provision 1 is allowed, but this is not allowed. The second provision is not allowed. Yes, you can implement actions, Article 39 BC, under the garb of 39 BC, but the courts have the power to check whether you are doing it for 39 B or C or not. Okay, the courts have the power to judicial review. So this is not allowed. First provision is allowed. And that was done in Keshavananda Bharati case, where doctrine of basic structure was given. Clear? Makes sense? Now, what are Article 39 BC? Article 39 BC says, Article 39B says, ownership and control of material resources of the community are so distributed as best to serve the common good. So, government can use property so that it serves the purpose of common good. Now, what is common good? That the government will decide. So, government, under this, government can acquire your property if it serves a common good. This is Article 39B. 39C says that the operation of economic system does not result in concentration of wealth and means of production to the common detriment. That the economic system is not such that there is grave inequality. If there is grave inequality, we can take action to take money from the rich and give it to the poor. This is 39C. Clear? Now, if government is doing so, taking action under these two principles, and a person feels that their Article 14, 19 and 31 is being violated, right? Well, they can go to the court and the court will decide whether the government is taking this action to implement this. If the courts find that yes, government is doing for BC, 39 BC, then the government would, the courts would allow that action. Otherwise, they would declare that action as unconstitutional. Clear? Makes sense? But do you know what? You should know this. The government of India, basically Indira Gandhi government, passed another amendment, 42nd Amendment Act. It is also known as the mini constitution. Okay, 42nd Amendment Act basically changed Article 31C. It says that if government is taking action to implement any directive principle from 36 to 51, any, not just 39 BC, any action implementing any directive principle, then that won't be questioned in the court of law that it violates Article 14, 19 or 31. Now, that was little problematic and that was challenged in the Supreme Court in the Minerva Mills case. And Supreme Court says, no, only 39B and C are allowed, not all directive principles are allowed. So, Minerva Mills case basically rejected or declared this provision of 42nd Amendment Act unconstitutional. Okay. This was back in the day when Article 31, not 31C, Article 31 was right to property. Though under 44th Constitutional Amendment Act, when Indira Gandhi's government got out of power and Janata Party government came, under 44th Constitutional Amendment Act, Article 31 right to property was scrapped and Article 300A was added, which guaranteed right to property. So it removed right to property from the chapter of fundamental rights and made it an ordinary legal right under Article 300. That's the principle, and I guess you know this. Clear? That would be all. And let's quickly jump to topic number 5, which is right to be forgotten. Now, what is right to be forgotten? Look, very simple. The thing is that, I'll give you an example. The reason why this was in the news. The thing is that there was a rape case in 2014. Clear? Now, that rape case, the person was accused, okay? But it was found in the courts that that person is not guilty. It was a false rape case charge, okay? And that person was acquitted. Clear? But the allegation against him for that rape was basically uploaded on Google also. You can find all these news on Google. Clear? Now, in 2014, that allegation was leveled and it was uploaded on Google as well. Clear? But what happened that after 3-4 years, he was acquitted. It was found that he is not guilty. But that allegation on Google was not taken down. Right? It was not taken down. So, that person on whom that allegation of rape was there, well, he's free now. The courts have found him not guilty. But as per Google, he allegedly raped someone. The news still exists. Okay. Now, this person was applying for citizenship in Australia. And when Australia gives its citizenship to anyone, well, they do a background check. When they did a normal Google search on him, they found that he's accused of rape. Now, this person explained to them that, look, a case was filed against me. I won that case. Still, the Australian government is not willing to budge because they say that, well, it is written online that you were accused of rape. Now, this person's life is getting damaged because of this. So, he has said that I have the right to remove this fact about me from online space. This is known as right to be forgotten. If there is damaging information about you, then that damaging information, you have the right to remove that damaging information, especially false damaging information, from the online space so that it doesn't affect your forward life, okay, future life. This is right to be forgotten. And currently, India does not guarantee right to be forgotten, though some Supreme Court judgments have allowed right to be forgotten. But there is no law, no rule with respect to right to be forgotten. But that is not the case in European Union. European Union categorically has enacted a law which guarantees right to be forgotten. In European Union, it is known as right to erasure. damaging information about you on social media or on online platforms should be erased. Okay. So what is this European Union regulation? Right to erasure. So what is the definition? It can be loosely described as the right to remove one's digital footprint where it violates the right to privacy. So it is considered a part of right to privacy. In May 2014, Court of Justice of European Union, the highest court of European Union, basically said in the famous Google Spain case that right to be forgotten is part of European law. Okay, it is part of European Union's Charter on Fundamental Rights. Later, they added this right to be forgotten explicitly in their General Data Protection Regulation. So they enacted a law, European Parliament enacted a law called GDPR. In that law, Article 17 categorically mentions right to erasure, which is right to be forgotten. Clear? Makes sense? Now, what is the situation in India? Well, in India, there is no law, but there is a very famous case known as the Puttaswamy case of 2017, which basically is a landmark case. Why? Because under this case, right to privacy was made fundamental right. Okay. And since right to be forgotten is part of right to be privacy, now people are filing petitions in the Honorable Supreme Court to give clarity because there is no law. So to give clarity whether right to be forgotten is part of right to privacy. And if it is, then right to be forgotten is also a fundamental right because Puttaswamy case of 2017 said right to privacy is a fundamental right. So remember Puttaswamy case. Okay. And with that, we conclude today's session. Thank you so much for watching, everyone. And I'm sure it has added value to your preparation. In fact, I am dead sure that it is adding value to your preparation. Please be consistent with this lecture series. It is really helpful. And please do not forget to download the notes for this lecture and the previous lectures of Prelims Powerplay series from our Telegram channel. Okay? Do not forget that because without revision, you can easily forget these lectures right before your exam. So if you are really careful and if you really want not to forget whatever we have covered so far, while appearing for prelims examination, please do the necessary revision. Okay. On that note, I'll be signing off with the promise of seeing you again with another lecture of Prelims Power Play lecture series. Thank you, everyone.